Hello, everyone, and welcome to today's Mondak webinar in association with Drua Al Amal. Our expert panelists will provide an in-depth explanation on personal data protection law in the Kingdom of Saudi Arabia, whilst also covering compliance and enforcement in other jurisdictions. My name is Dan Sampaio, and I'm joined by a brilliant panel to take us through today's discussion. Saifullah Khan is an international trade, privacy and policy lawyer and has more than 25 years of diversified multi-jurisdictional professional experience in the areas of international trade policy and law advisory. He also practices data protection and cybersecurity, antitrust and competition law, IT and e-commerce, trade agreements, issues relating to tariff and non-tariff barriers, and alternate dispute resolution mechanisms like mediation and arbitration. He has advised numerous clients in this regard and has also represented clients before the executive and judicial forums. Saeed Hassan Khan has more than 25 years of diversified experience in rendering various professional services to a wide range of clients. He has developed a keen professional interest in emerging laws about personal data protection and has gained an understanding of underlying concepts and principles governing the global data protection laws, including the General Data Protection Regulation of the European Union. He advises clients on privacy policies, compliance, cross-border transfer of personal data, and related advisory concerning personal data protection. And completing today's panel is Hannah Hewitt. Hannah focuses on cybersecurity and data protection, helping clients navigate an increasingly regulated area in the UK, EU, and beyond. She provides privacy advisory support, advising clients on the GDPR and other international data protection laws on issues including data retention, processing, and transfer. On incident response, she advises clients on immediate response and post-incident remediation work, including ongoing cyber risk management, managing correspondence from regulators and other third parties, and assisting with privacy compliance updates. Before we begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many of your questions as possible. It's now my pleasure to hand over to Saifullah, Saeed and Hannah to begin. Thank you.
Thank you very much, Dan. Assalamu alaikum and hello to all our participants and welcome to this webinar on Kingdom of Saudi Arabia's Personal Data Protection Law, which we call in the short form as PDPL. The aim of our webinar is to give you an overview of this law, highlighting its importance in safeguarding personal data and enhancing privacy protection. We will delve into the fundamental concepts of the law and highlighting some compliance requirements which organizations who are processing the personal data, they must follow. Moreover, we will discuss the regulatory mechanism overseen by the regulator, which is Saudi Data and Artificial Intelligence Authority, we call it SADAIA. Moreover, in order to enhance our understanding, we will get some information and insights from the UK and the EU GDPR implementation. And we are lucky to have Hannah with us from London joining as a speaker, and she will be sharing her experience about the General Data Protection Law implementation in the UK and in the EU. And finally, we will just give you some basic idea about how this law can be complied with by organizations who are processing the personal data. So to start with the legal framework, please switch the slide. Yeah, this law has. Can we get a bit slide format maybe? Can we see this in the slide mode? Is it possible, or this is the maximum size?
Hi, Saifullah. If you click on the pin button on the screen, you can make it larger for yourself.
Just a minute. Okay. Okay, this personal data protection law, the latest version is issued on the 9th February, and the decree has already been issued. And we have two relevant regulations: the implementing regulations of the PDPL and the regulations on personal data transfer outside the kingdom. Next slide, please. Okay, it is important to actually understand the purpose of the personal data protection law. Before going into these four points, which are the basis of the framework, I think we all understand and we all appreciate that we live in the age of digital, and all our daily life transactions are now being done digitally. So digitization has poses some risks on the privacy of the individuals, and the more and more we use the digital framework, the digital tools, I think there is a more risk of privacy that is in front of us. So, in order to address such risks, which is increasing every day, the law has provided certain parameters. The first one is the balancing the rights, which means the basic purpose of this law is to balance the right of individuals and the interest of the organizations who process their personal data for illegal purposes. I mean to say that on one hand, it is the fundamental right of individuals to have their data kept private and the protected properly. But on the other hand, the proper and legitimate use of personal data by organization is also allowed. So there is a balance created by giving right to the individuals which are data subject, and giving obligations to the processor of the information, which is a data processor and data controller. There is an obligation of users of personal data, which means that the organizations or the persons who collect data from individuals who are data subject, they have to follow certain principles, certain obligation under the law, which includes accuracy of uh, the data which they maintain. They need to have the security of the information that they collect, and they need to process information for a specified and legitimate purpose. And in case there is any breach of personal data, they have to report to the individuals as well as to the regulator, which is SIDAIA. So the law provides certain obligations for the person who processes the data. Then there is an autonomy to individuals. So this law actually provides right to the individuals, and that right is that their data should not be used without their wishes, without their approval. And this law provides you a right that you can request the data processor to erase your data, to amend your data, update your data. So these are the rights and the autonomy that is given by the law to the individuals. And finally, the enforcement by the regulator, which is extremely important, that the enforcement of the law by the regulator is the primary key for the success of this enforcement, actually. And the regulator actually has the right to oversee the compliance requirement in the country, to process the complaints filed by the data subject and other interested parties, and as well as to take action in case there are violations, and to impose penalties as well. Next slide, please. There are certain fundamental concepts basically in the law. There are a number of definitions in this law, personal data protection law, but I'll just briefly touch upon just a couple of them, which are instrumental and fundamental to the law. The personal data, actually, the first one, personal data is any data or information which identifies an individual. Could be your phone number, your email address, your postal address, or any information which can identify individual. The sensitive data, on the other hand, is more critical information, which is more protective, and it is more private, basically, like your thumb impression and any your religious or philosophical belief, or your genetic, or your any other kind of a medical record, for example, is also sensitive personal data. So there is a slight distinction between the definition of a personal data and the sensitive personal data. Next slide, please. Then there is a very important concept in the law of data subject, controller, and the processor. So I'll just briefly touch upon each of them. Next slide, please. Data subject basically is the individual whose data has been processed, has been collected, and for some legitimate use. Next slide. Controller is basically a person or organization who actually take decision about the collection and the processing of information. So controller is someone who decides to collect the data and process the data for some specific legitimate use. Example is the hotel industry. When you check into the hotel and they take your personal information for a record, so they are data controllers. Next slide. Data processor, on the other hand, is somebody who processes data of individuals on the direction of data controller. So the decision to collect and process data is for the controller, whereas the processor is only processing a particular set of data on the request or the requirement of data controller. Next slide. There are certain principles of processing of data which are of primary importance. For example, the basic requirement of the principle is
Sepula, I will continue from this slide.
okay. I think you take away. You take the floor.
Thank you,
Yes, over
Sepula.
to Said.
Thank you, Sepula, for setting the floor. And I will discussing about firstly the principles of processing. So, as Sepula has mentioned, that there are some basic principles or the purposes of introducing of personal data protection law. Now, these fundamental purposes, which Saifullah has just mentioned, are the foundation stones for building further regulatory and the compliance requirements under the PDPL. So, before starting to implement the personal data protection law, we must need to have a fair understanding of what are the principles of processing. So, the law gives 7 broader principles of processing. The first principle is known as lawfulness, fairness, and transparency. When we talk about lawfulness, fairness, and the transparency, it goes to the basic principle of the basic purpose, as just Sapula mentioned about the autonomy to the data subject. That means that every controller who uses the personal data of natural person, he must be very fair, transparent, and open right from the beginning of the collection of data. They must be very transparent. Then another principle is purpose specification. Although, as Sepula mentioned, that we are living in the digital age, and the purpose of law is to keep a balance between the interests and rights of the data subjects and the data controllers. At the same time, data controllers are not given a free hand to use any information. So they must have a specified purpose. They need to collect information for a specified purpose, and this purpose is limited to that only purpose. That means if a data controller is to collect information for a specified purpose, it cannot be used for any other purpose. The next principle is for the accuracy. Data controller is required to keep the personal data very accurate in relation to that purpose. And then the principle of data minimization and data storage limitation, which means that only minimum amount of personal data is to be collected in relation to fulfillment of the purpose of its collection. And once the purpose of collection is completed, the data is to be destroyed permanently. Accountability is a very important principle because, as Saifullah says, that The purpose of the PDPL is to bring obligations on the users of personal data who are controllers or the processor. So the controllers and processors are accountable for their data practices, and they are to ensure the compliance of the PDPL. This is the principle of accountability. Last principle is the protection of the personal data. We know the name of the law itself is protection of personal data. So the requirement of the law, or the basic principle is that the controller and processor is to take every necessary step in order to keep secure, confidential the personal data. When we say the controller is to keep secure, it means that it is to be secure from unauthorized access, damage, or unauthorized use. And so next slide, please. So when we start to the compliance framework, how the companies or the controllers or the processor within their organization need to develop a compliance framework. So the very first compliance requirement is that every organization, which is controller or the processor, must fully aware and know what are the lawful basis or the reasons or the valid reason for which they are using the data. So law specifies, I mean the personal data protection law specifies certain specific legal reasons. So every controller or the processor should always select or choose at least one of the legal bases. If the six bases, which I'll explain shortly, if not any one of them is not available to the controller cannot process the personal data. So first lawful basis is the consent. Consent is a very basic and fundamental sort of lawful basis under which a controller can process the personal data based on the consent given by the data subject. We'll discuss the consent later in much detail. Then the other lawful basis is the contractual obligation. It means that this lawful basis is applicable when personal data is being processed by the data controller because of entering into an agreement between data subject and the data controller, and the data controller to fulfill its obligations under the contract to which data subject the party can process the personal data. The third basis is legal obligation. Legal obligation is that in some situations, controllers or the processor are to comply with certain other laws. For example, for the employment law, for the immigration law, for the taxation law, for the anti-money laundering law, for the financial institution to check their KYC, know your customer requirements, they have to process the data under any legal obligation which is incumbent upon the controllers under certain other laws. Then there comes the legitimate interest. Legitimate interest basis is very beautiful basis to, again, it's stemming out of the very first purpose of the law, the balancing of the rights. So legitimate interest is the requirement when data controller is allowed to process the personal data when there is a equal benefit to the controller and to the data subject. And then the actual interest, the fifth one is the actual interest. It means that when there is some danger, there is some emergency, and data controller is to protect the health or physical safety of the data subject. In case of emergency, he can use the personal data or process the personal data. The last lawful basis is for the law enforcing agencies or the judicial department to process the personal data to carry out their official obligations and the duties. Next slide, please. Carrying on the compliance framework, SDAIA, as Sepula has mentioned, as Saudi Data and Artificial Intelligence Authority, is the regulator to implement and enforce the personal data protection law in the kingdom. So there is a requirement, SDAIA is keeping a national register for controllers. So in certain circumstances, controllers are to get themselves registered with the SDAIA in the register of national controllers. So every public entity is required to be registered, and for private sector entities, if they are processing sensitive personal data, or if their main function is or their main business is focused on processing of personal data, then they need to have registered themselves. If case the controller is an individual and he or she is processing the personal data beyond the personal use limit, then that individual is also required to be registered with the SDAIA. Next slide, please. The next obligation or the compliance requirement which I would like to discuss here is the appointment of data protection officer, which say DPO. So DPO is basically an officer who can be an employee of the controller, or it can be an outsourced function to some expert outside companies. What is the role of DPO? Basically, DPO acts twofold. Firstly, it acts as a bridge between the controller, between the data subject and the regulator. And secondly, his or her job function is to oversee the monitoring of the compliance of his employer, which is controller of the processor, with the personal data protection law. Now, when DPO is compulsory required to be appointed, it is to be appointed in case the controller is public entity, or the controller is monitoring the data subjects, or when processing sensitive personal data. In these all three cases, appointment of data protection officer is mandatory. The next slide, please. As I mentioned that when I was discussing that there are six lawful bases or the legal reasons under which a controller or processor can process the data, and one of the, or rather the very first legal basis was the consent. Now, what is the consent meant for the controller to be compliant with the PDPL? It means that the controller must obtain an appropriate consent, a free consent, and documented consent. The documentation of the consent is very important because the consent obtained should always be available to be retrieved whenever it is required in case of complaint or in case of any data breach. Next slide, please. Again, the next compliance requirement is to keep the accurate record of the processing activities. So each controller or the processor is to record a full record of processing, and it's again related to the principle of transparency, because then whatever I'm processing, I should be able to demonstrate before the regulator, and if required, before the data subjects. So what records as a minimum are required to be kept, like the particulars of the controller and the contact details of the data protection officer. The purpose of processing, as I mentioned, that the principle is that we have a specified purpose. So we need to record what purpose we are processing the personal data, what personal data categories we are processing, for how long we will keep the personal data. Are there any third parties to whom we will be sharing the data? I mean, the controller will be sharing the data. And if there is a case that the controller is transferring personal data outside the kingdom, so this also be recorded. And finally, again, in order to protect and to safeguard the personal data, what protection and what security measures are being adopted by the controller or the processor, this all need also to be recorded as a record of processing activities, and we say it ROPA, record of processing activities. Next slide, please. Another important compliance framework is privacy policy. Again, the privacy policy correlates with the principle of fairness and transparency. So the controller at the time of collection, of very time of the collection of personal data, is required to inform the data subject who I am, I mean who the controller is, what is his purpose to collect my individual personal data, how it will be stored, how it will be collected, how it will be distributed, and more importantly, what rights are available under the PDPL to the data subjects, and how the data subject can exercise these rights. Next slide, please. Data protection impact assessment has two elements. Firstly, it serves as a risk assessment tool. Data controller and data processor in certain situations is legally required, mandatorily required to carry out a data protection impact assessment. And the very purpose of the data protection impact assessment is to assess, are there any risks arising out of the processing of personal data? And if some risks are recorded, then what remedial actions are required in order to protect the personal data. So data protection impact assessment is required in certain situations, like if controller is processing sensitive personal data, or controller is processing personal data of those individuals who are lacking legal capacity. For example, they are the minors or they are not in good health. If the job of the controller is to continuously monitoring the data subject, or they are making decision on automatic decision making, or importantly, when processing is based using advanced or new technologies. For example, if processing is based or being used through the means of Internet of Things or through use of artificial intelligence, then data protection impact assessment is a legal requirement to carry out. Next slide, please. SEPALA has defined in a very simple way the concept of controller and processor. So I just to repeat very briefly, controller is a person or an entity who decides the purpose of collection and use of personal data, whereas the processor is a person who does not have its own purpose determination, but it acts on behalf of controller. It's a third party arrangement. So because the purpose of the law is to protect the personal information of the natural person, that are data subjects, so controller is obliged to select or appoint a third party processor through a well binding and well written documented agreement which ensure that processor takes all the responsibilities under the personal data protection law in order to protect the personal data of the natural persons. So the contract should be very comprehensive and should cover the specific guarantees by the insurance that he is available and he should be available to protect the personal data of the natural persons. Next slide, please. Very importantly, we have said that the purpose of the law is to make a balance between the interest of the natural persons who are data subjects and the interest of the controllers. So for that purpose, personal data protection law has conferred certain rights on the data subjects. When we say that the law has given rights, it means that these rights are enforceable under the law, which essentially means that a data subject can ask the controller to give me this right. I'll explain this right briefly. But in case the controller is unable or fails to fulfill this right, so the data subject can bring the data controller before the SADAIA or the regulator to impose penalties and fines or take remedial action. So what are these rights? And again, these rights are stemming from the principles of autonomy and transparency. Right to be informed, very transparent. The data subject has the right why my data is being collected, who is collecting my data, right to access to personal data. If I'm being a data subject, I have the right to go to the controller and say them, please give me a copy of data which you have of mine. Then if I see that uh, I need to have the copy of also my personal data. I can, if I feel as a data subject that my personal data being kept is inaccurate, I can ask its correction, and also I can ask as a right to the data controller to restrict my data. And when I say as a data subject, when he exercises this right specifically for the restriction, that means the data controller will no longer be processing his or her personal data. Next slide, please. Another very important compliance framework is to report the breach. We all know that in these digital days, irrespective that we are taking too much care, we are protecting through cybersecurity means and technological means, but the chances or likelihood of data breach or unauthorized access are there. To cater for this, the law requires that whenever there is a data breach, compromise is there, then the controller is to report the incident to the SADAIA, who is regulator, and to the data subject. Very importantly, this breach reporting is required to be done within 72 hours of coming into knowledge of the controller that breach has happened. And the SADAIA has made an enabling platform, a national data governance platform, which is managed by SADAIA. So controller or processor is to report any data breach through this platform at the SADAIA website. Next slide, please. As I mentioned that the principle of processing, the last principle of processing was the protection of personal data. So Article 19 of the Saudi Personal Data Protection Law says that controllers is to take necessary administrative, organizational, and technical measures in order to protect the personal data. Now the law does not define what specific parameter, what specific measure is to be taken by any respective data controller. Rather, the law uses the word of necessity. That means that law gives it the choice to the controllers to decide what technical and organizational measures are required in each specific case. So, as a general practice, as a good international practice, I would just like briefly to discuss or highlight the common organizational and technical measures, like for example, development of documented policies and procedures is a very important organization measure, so that the purpose of the development of policies and procedures is that all the employees or the staff in the organization who is controller should know what need to be done in special circumstances. I just in earlier slide asked about I discussed about the personal data breach reporting. So incident response plan is also a critical organization measure, which means that organization should develop a documented incident response in case there is data breach, what to do, who is to report, how to take backup, and how to report to the data subject, how to report to the SADAYA, the regulator, and importantly, how to recover the incident. So this is also a very important administrative measure. Third party management is also an important organization measure, which I discussed about regarding the appointment of a processor, which is a third party management. Employee training is very important because employees should know, because personal data is being processed by every staff of the controller. So employees should be well aware what are the requirements of the personal data protection law, and the employee must always be known about the policy and procedure and how to implement this. So employee training and their capacity building is a very important element. Then, for example, to encourage a culture where to use strong password practices to ensure that to avoid any unauthorized access. Safe browsing habits is also another important element of the administrative measures. Lastly, the regular audits, because if everything is going good, but it's always advisable that quarterly at least the data controller should take a compliance check or the random examination that for the last 3 months was there any non-compliance or not. Next slide, please. Again, I have just discussed about the organizational and the administrative measures. Now I will discuss the technical measures. Again, the law does not specify any particular technical measure, but as we've seen from our practice globally in different countries and in different jurisdictions, the data encryption is one of the technical measures to protect the data. Access controls in organizations, the data access to data is to be role based. Every individual, every employee should not have the access to all of the data. So it's a good technical measure. Regular software updates, because technology is moving too fast. So the organization should keep regular software updates to keep the information secure. Because most of the data is transferred through networks between the organizations and between the segments of the organizations. Therefore, network security is also an important element to have the technical measures. Data masking and anonymization is also a technical measure to help protect the personal data, and more importantly, in case there would have been any breach. So it's always good to have a regular. We say sometimes it always has a cost, but a weekly or 10 days backup and recovery, so that just in case we have lost my data, but for the last 10 days or for the last 10 weeks, we have our backup data. Next slide, please. Uh, One of the purpose to develop these laws across the different countries is that, as Stefan has mentioned, that we are living in the digital economy. Now the transaction is cross-border. We are sitting over here, and my data is transferred to so many other countries. So too many and significant amount of transfer of personal data from one country to another is also one of the reasons to develop these laws in many of the countries. So the PDPL, the Personal Data Protection Law, do allow transfer of personal data outside the kingdom to any other country, but under certain circumstances, and there are three specific instances where a controller can transfer personal data from KSA to any other country. So first situation is SADAYA, the regulator, is to issue a list of adequate jurisdictions. Adequate jurisdiction means that SADAYA assess that in certain countries, uh, those countries provide a good and adequate protection to the personal data. So when this list has not been issued so far, but when this list is issued, the controller can easily transfer the personal data from the KSA to each of the country included in the list. If as mentioned that as of now the list has not been issued, number one, and secondly, if and when the list is issued, and name of the particular country or jurisdiction is not there in that list, then the other means available to the controller to transfer personal data from KSA to outside is appropriate safeguards. It means that controller can transfer the personal data through standard contractual clauses, which means essentially a contract between the controller, a transfer, and the transferee outside the jurisdiction. That based upon this contractual obligation and agreement, basically it's an agreement. Based upon this agreement, he can or it can transfer the data. Binding common rules also an instrument through which personal data can be transferred outside. So lastly, the accreditation principle. Sadaya is again to issue licenses to different agencies to have accreditation. And if any controller has got accreditation by the Sadaya approved accreditation agency, it can also transfer personal data outside the kingdom. Lastly, to capture the overall transfer of personal data in other situations. So if kingdom is a party to a treaty and in order to fulfill its treaty obligation, data can be transferred in the best interest of kingdom. The data can be transferred, and more importantly, in private circumstances, if a controller is to provide some benefit or services to a data subject, then controller can also, in that also in case also, that personal data can be transferred outside the kingdom. Next slide, please. Now I will discuss because what are the enforcement mechanism provided in the personal data protection law. While Saifullah, when opened his discussion, he said that there are four major purposes of development of the law. And the last purpose, he mentioned that there is a regulator to enforce the law, and the regulator is SDAIA, so the Data and Artificial Intelligence Authority. So in a nutshell, SDAIA is responsible to enforce and implement the law. And for that, it has got all the powers. And more importantly, I will highlight to complaint handling. When data subject makes a complaint, SDAI has to, receive the complaint and make decision on that. And at the same time, SDAI is empowered to issue warnings and to impose fines. Next slide, please. Continuing on the enforcement, there are some penalties for the contravention. In some certain cases, there could be an imprisonment for up to 2 years, and the maximum penalties can go 3 million Saudi riyals. And if the offense is repeated, the amount of penalty can be doubled. And lastly, there is a concept of compensation. If a data subject, like an individual, suffers a material or moral loss out of the data breach, it can go to the competent court for awarding a compensation. So this ends my slides, where I try to highlight the compliance requirements. And now I'll hand over to Hannah for discussing the insight from EU experience.
Thank you so much, Saeed. And I'm just going to start by saying I've had some headphone trouble at the beginning of this webinar, so I'm hoping you can hear me. But any issues, please just pop a comment in the chat, and I will try to address them on my side. So flying west then to Europe and the UK, how does all of this compare to when the GDPR was enforced in 2018? Back in 2018, companies were faced with either having to update their existing privacy programs or implement new programs depending on the stage of their compliance they were at. And the reason I say that is because the GDPR wasn't entirely new, and I think that's a key distinction to make here when discussing the PDPL. The GDPR built upon previous legislation that was in place that sought to protect personal data, and so built upon that and expanded the scope of what the legislation covered, both in terms of companies that were caught by the GDPR, as well as obligations that companies were under. So given that's the case, and given that legislation was already in place prior to the GDPR to protect personal data, why were companies taking this more seriously in 2018? And there's a few answers to that. The first being the fines. I'm sure most people on the call are aware of the fining regime under the GDPR, which is up to 20 million euros or 4% of a company's entire global turnover in the preceding financial year, whichever is higher. And we really have seen regulators flex their powers there and seek to implement high fines to encourage compliance. Also, at the time in 2018, there was an increased interest in privacy overall. This came off the back of Edward Snowden and discussions about surveillance and the importance of personal data and its value to states, companies, etc. So there was a lot more interest on a personal level in privacy and companies' compliance with privacy laws. And I think also a distinction to be made here is because there was legislation in place prior to the GDPR, the regulators were already established in all of the EU jurisdictions, which meant that there was a real fear on the date on which the GDPR was enacted that regulators would take action within the preceding week, month, year, and that as an attempt to show and flex the new enforcement powers that they had. So there's a real fear on that side of things. And added to that, the GDPR did bring in new obligations, and there were bigger papering exercises that needed to be carried out by organisations. What I thought it might be useful just to also touch on is some of the takeaways that our clients had after GDPR enforcement, and because I think some of them might be useful for clients now, considering how to go about implementing the PDPL. I think the big thing is don't panic. Build on compliance strategies that you already have in place to comply with the GDPR or any other privacy regimes internationally. Don't necessarily reinvent the wheel, because I don't think it's necessary. And also look at the market and see what approach other people are taking. Where are their key focus areas? There will be key compliance points that are perhaps easier to address straight away, and others that you need to take a bit more time, go back to the business, think about how you're operating at a bigger scale, and think about the public facing issues, as those are the ones that the regulator will likely be able to quickly identify as being gaps in any compliance program, which I think you'll see in the following slides. So if I can move to the next slide, please. So how have we seen our clients navigate the fractured regulatory landscape? And I hear quite a lot of people describe the privacy landscape as fractured, but in reality, as Saifullah and Saeed have set out, quite a lot of privacy regimes internationally draw on principles and obligations set out under the GDPR. So in some ways, the very easy first step for companies operating at an international level is to look to the GDPR, which is often regarded as being the gold standard for privacy compliance, and try to get in a position where you're as compliant with the GDPR as possible. And that will set you in good stead for complying with privacy laws internationally. Most of our clients often then look to the US because there's fast emerging US state privacy laws, and that can be a complex task given the competing and completing obligations under some of those laws. And then other jurisdictions, our clients tend to review on a case-by-case basis, and that review will depend on multiple factors, which includes the business's growth strategy, where they're looking at markets they're looking at moving into, also markets that they're currently in, and markets that are very important to them. It will consider factors like how active the regulator are and how the fines for non-compliance, and also will depend on companies' overall risk tolerance. So key takeaway, always a good starting point is look at the GDPR, because a lot of the obligations that Saeed and Saifullah have set out today stem from the GDPR. And then from there, build up a compliance program that focuses on countries of importance to your business. Next slide, please. So in terms of enforcement under the GDPR, what have we seen since 2018? I think as these two graphs show, these graphs both show the volume of fines and the sum of fines. There's been an increase in both since 2018, and I don't think that's surprising, especially as regulators and individuals become increasingly more aware and conscious of data protection issues. The enforcement priorities per country in the European Union differ, and they differ quite substantially. So I've put on the slide two examples to really highlight this point. The first being Ireland, which since 2018 has issued 29 fines, which total over 3 billion euros. And the second is Spain, which have issued a much higher number of fines, totaling 899, but the value of those fines only amounts to 83 million. And the reason for that difference is Ireland is the country where most of the big tech companies are established. So the Irish Data Protection Authority is very keen to make an example of these companies by issuing extremely high fines, which I've got a few on the next slide when we get to it. It will be interesting to see whether that trend continues. I know there is some concern with what we're seeing with the political landscape in the US. There's some concern amongst data protection regulators in the European Union as to whether they should continue to be ordering these big tech companies to pay large sums of money. So watch this space. But in terms of Spain and why their fines are higher but the value is lower, the Spanish Data Protection Authority takes a different approach. They're focused on smaller incidents. We've seen examples where the Spanish data protection regulator has issued fines to individuals over their use of CCTV on personal property, which we don't see in other jurisdictions. And then just also adding there from a UK perspective, the UK Information Commissioner's Office, the data protection regulator in the UK, is very focused on issues such as the use of cookies and tracking technologies on websites and direct marketing. So the priorities of regulators in different jurisdictions differ, but the overall trend is that enforcement actions are going up. And we tend to see the fines being issued the most in the media and telecoms and broadcasting industry, and then within industry and commerce, which is perhaps unsurprising given the public-facing nature of these companies. Next slide, please. So finally, I've just put on the slide some examples of enforcement actions taken by European data protection regulators against companies for some of the common contraventions of the GDPR. And as I alluded to earlier, these contraventions are, for the most part, issues that are public facing, because they're issues that are easy for an individual to complain to a regulator about, or indeed a regulator to come across themselves. So public facing issues include privacy policies, responding to data subject rights requests, and we've got on there LinkedIn, who were fined by the Irish regulator 310 million for a failure to comply with Article 13 and 14, which are the provisions under the GDPR that relate to the requirement to produce and publish on your website a privacy policy. We also have their inappropriate technical and organisational measures to protect personal data. So in September this year, Meta was again fined by the Irish regulator 91 million euros after it inadvertently stored certain passwords of social media users in plain text internally. I've seen this week that Meta is actually challenging that decision. It's not clear to me at the moment, based on publicly available information, on what grounds. So it will be interesting to see if that fine comes down. But Meta has been targeted quite a lot recently by the Irish data protection regulator for a range of different issues and alleged breaches of the GDPR. We've also got the international transfers of personal data, which Saeed mentioned is also a point to consider under PDPL. The biggest case there is Uber. The Dutch Data Protection Authority fined Uber 290 million in August 2024 for transferring personal data of European taxi drivers to the US without implementing sufficient protections. And this is an issue that we find clients regularly have to think about. As my colleagues on the call have alluded to, we're living in an increasingly interconnected world, and our clients are increasingly operating in more than one jurisdiction. And this is a real issue and something that regulators are looking into a lot more. And then I also thought it'd be useful to flag some non-GDPR contraventions. So the collection of personal data using website cookies and other tracking technologies and sending of marketing materials are actually regulated under a slightly different piece of legislation under European and UK law. But feed into some of the general principles under the GDPR, and are often kind of grouped together with when companies are looking at GDPR compliance. And the case I've got up there is TikTok, where the French Data Protection Authority fined TikTok 5 million in January 2023 for making it difficult for users to refuse cookies on websites. So this comes down to how cookies are presented to a user and how easy it is for those to be accepted or rejected. Things like not allowing a user to reject full stop, or graying out the accept box to the reject box to encourage users to click accept instead. And we're increasingly seeing interest in that area, given, again, the public facing nature of those issues. But I'll pass back over to Saifullah now to wrap up and end with key takeaways.
Thank you very much, Anna. After having discussed the basic principles of this PDPL law, the rights of data subject, and the obligations of the data controller, as well as a very important role of the regulator, the question here arises how the organizations who process personal data of individuals who are data subject, how the data controller should make sure that he should comply with the law, the KSA PDPL. So this is the way forward for compliance for the data controller. The first step is the situational analysis. You have to see what kind of personal data your organization is processing, how the data has been obtained, and the whole process of control to immediately, you should be able to identify some risks which are associated with the processing of data currently. Then the compliance framework has to be established, which means that you have to identify and design processes and controls to make sure that you can comply with the PDPL law. The gap analysis is the next steps, that you need to see your organization fails in certain areas. And if it is so, you have to fill up those gaps. And how do you fill up those gaps is the next step of policies and procedures. So you need to have written policies, procedures, templates, and forms in place to make sure that you comply with the law. The next is the contracts and modification in the current contracts, which means that either you have to enter a new contract with your suppliers or customers, or you have to modify your current contracts to include the PDPL obligation into your contracts with your suppliers and customers. The next step is the capacity building. You need to organize capacity building sessions and programs and workshops, etc., in your company, in your organization. You have to enhance the capacity of your employees, your staff, and they should know basic principles of this data protection law, because otherwise they will not be able to properly execute what is required by the law, and then the breach could be very harmful for the organization, as Hannah and Saeed both have highlighted in their interventions, that the fines are quite high. The amount of the fines are huge in these laws. So in order to avoid such fines, you need to have a proper and very well trained staff in your organization. Finally, the review and updating. You need to have a review mechanism in your organization to make sure that your compliance measures are updated and effective at all times. So these are some of the steps which the organizations who are controller, they must follow in order to comply with the law. The enforcement is already there in KSA, so I think we do not have any time left for further preparation or further thought process for the data controllers, and they should immediately try to develop the compliance framework as soon as possible. And this is what we are doing currently in Saudi Arabia, helping companies, data controllers to design and the compliance framework, and assist them to maintain that for a long term period. Thank you very much, and back to Saeed.
Thank you, Saifullah. Thank you, Hannah. And I'll take a question from our audience now. So there is a question from Vishal. If any shipping company wants to implement the KSA PDPL, then what all steps they need to follow? I suppose Vishal Saifullah has just explained the way forward in his last slide, and it's starting from the data mapping exercise or the situation analysis exercise to the review and update of the policies. So he already explained and addressed your question. And Vishal, you have also asked another question. Does PDPL will be applicable to any company if it has only representative office in the KSA? So the requirement of the applicability of PDPL is on the processing of personal data from Kingdom, irrespective of the legal status of the controller or the processor. So if the controller is a LLC company or the public joint stock company or a branch office or the rep office, irrespective of legal status of the controller or the processor, the PDPL will be applicable only on the simple factual thing if that legal entity is processing personal data of the natural persons. Then we have
May I just intervene? May I
yeah,
just intervene before you move into the other question? Just the participant who asked the first question, I just want to make one point clear that we recently actually before September deadline, we work for a financial institution here based in Saudi Arabia, having more than 100 branches all across Saudi. And we developed that compliance framework considering the way forward methodology that I had explained. So we have already implemented the same kind of a methodology in a financial institution in Saudi Arabia. So the companies, they follow this methodology in order to make sure that they comply with the law. Thank you.
thank you, Saifullah, for reminding this point. Now we have questions from Alessandra. There are a couple of questions. And the first question is: in addition to appoint a DPO, is there an obligation to register the DPO with Sadaya, and if so, when? So, whenever there is a requirement to appoint DPO, it's a mandatory requirement, but it is not required to register the appointment of DPO with the Sadaya. However, having said that, the name and particulars of DPO is required to be mentioned on the privacy policy and the privacy notice. Although we don't need to have notify the Sadaya about our DPO, but we need to mention his particulars and the contact details, more importantly, within our privacy policy, so that our data subject can access to make data subject requests or anything. Another question is, all data breaches are to be reported or only those who may cause harm to the data subjects? This is a very important question. Actually, the law says that any data breach which may result in a serious harm to the privacy or the interest of the data subject, that breach is to be reported. So to come across that conclusion or that determination, data controller has to make a determination whether this breach is going or potentially going to seriously harm to the interest or the privacy of the data subject. So once the data controller has this conclusion or the determination that this is a very harmful breach, then only it is to be reported. So these
Can
are
I
the
can I
questions.
just can I just add a couple of can I just add one more thing about this question, that it is not easy actually for data controller to determine itself that whether this would have some harmful effect on the data subject or not. So initially, probably it is advisable not to take this kind of a risk and try to report the breaches to Sadaya more oftenly until and unless you have the experience to understand it properly and look around the practice being followed in Saudi and in other jurisdiction. And then if you believe that you are confident enough to make sure that a particular breach does not have any negative implication on the data subject, and then you may decide not to report to the Sadaya. Otherwise, non-reporting leads to fine. So in order to avoid fines, it's better to report.
Thank you, Saifullah. The last question, because we are running short of time. Do we have list of adequate countries list? I mentioned that as of now, SADAI has not issued, but as sooner it is issued, it will be available on SADAI website. The last question is there any deadline to register the entity and appoint DPO? No, there is no deadline. the sooner it become applicable to the entity to appoint the DPO, or the company concludes or the controller concludes that it is required to be registered, it has to be registered forthwith. And if we delay, this is a contravention, and it may attract some fines and imposition of fines and penalties. So all questions are
One thing,
covered as of now.
one thing I would also like to add here, that please feel free to send us your emails for any questions subsequently. We understand this time, 1 hour is quite limited time period. So if you think of any question later on, please feel free to send us an email and we will respond to you immediately.
Thank you, Saifullah. Thank you, Saeed. Thank you, Hannah, for your time today. It's been a pleasure to spend an hour in your company and for your insights and thoughts on a very important topic. Saeed, if you have any closing comments to make, please do now. But I just want to say thank you once again to our panel, and thank you to our audience for being with us today.
Thank you very much, Dan, and thank you everyone who have joined this webinar. Thank you.
Thank you all attendees, and we are available to answer your question if you have any further. Thank you.
Absolutely. Thank you. Have a lovely rest of your day, everyone.